Welcome to the latest edition of ICLG Meets, and it's a chance for you and me to get under the skin of some of the world's top legal minds, and one of them is here right now. He's a partner at Hausfeld. He's got a commercial litigation practice spanning complex international disputes, arbitration, regulatory investigations in all sorts of sectors. So it only remains for me to say, Greg Lascelles, hello.
Hello, good afternoon.
Thank you so much for joining us. Now, you've worked for many years across complex commercial litigation, regulatory investigations. How would you sort of generally characterise the current disputes landscape, both here in the UK and internationally, and what feels different compared with, say, 5 years ago?
Well, I think if you look at the way law firms are organised and the litigation groups within them, what you can see are, in a sense, distinct blocks where you have specialist litigation and arbitration and regulatory practices, and perhaps a more general one. So I would put within the blocks areas such as competition litigation, such as insurance litigation, construction litigation, such as employment, and those kind of areas where there are specific and large pieces of litigation. Restructuring and insolvency is another of those. And then you have the more general, which is where the pop-ups that come in every day on what the court is doing tend to show you the normal run-of-the-mill cases such as negligence, such as procurement and bidding process disputes, such as fee disputes, also employment disputes within that. And then perhaps a subset of two subsets. One, what I might call regulatory litigation, which would be litigation around regulatory areas such as sanctions. And the other would be arbitration disputes where they go to court, so where the court is involved in reviewing an arbitration on a point of law or substantial irregularity, or on points like sovereign immunity and the like. So there's a block pool and a general pool. And I should add, obviously, the competition and consumer, the mass claim side is something that's coming to the fore.
Sure. And I mean, and on the mass claim side, I mean, it's interesting because it all, in the UK, they all take place, they're all funneled through the Competition Appeal Tribunal. I know class actions aren't necessarily at the core of your wheelhouse, but it is interesting, isn't it, to see how some sort of claims are shoehorned as a competition claim. And I've often thought it's odd that mass claims should, why competition? Why not consumer protection? Why not something else? Why are mass claims class actions in the UK, do you think, limited to competition? And do you think the Competition Appeal Tribunal's remit, maybe even with another name, will be widened?
Well, of course, they weren't initially supposed to be just competition. In fact, I think it was the Brown government that first mooted it, and it was supposed to be financial redress, supposed to be on the that sort of consumer side, but specifically financial. And then it sort of morphed into competition, and we've seen a growth, obviously, in claims, but also growth in the nous and ability and the progress of those claims, so that it's becoming, if not necessarily maturer in there. There have been attempts, and there always will be attempts to be creative and to possibly, on some, for some people, you're shoehorning in a misuse of private information issue into a competition action. But I think you find that in any case with competition law, a lot of your breach of contract claims that would have ordinarily had a breach of contract, possibly a tort element to it, now have competition angles to them. So that was already happening anyway, and so I think it's probably an extension of that sort of legal creativity. And of course, the CAT has this ability to look at these mass claims on an opt-out basis. That's not to say there's not activity in mass claims outside competition. So, for example, the securities actions that we may talk about under Section 90, Section 90A, there's a lot going on there, very much in its infancy, I suppose, but there'll be a big case later on this year.
Are you able to talk about that specifically? Is that the public domain?
Yes, it's known that there's going to be a hearing in the Glencore case.
Oh, right.
I think it's quite a lot later on this year. But there are other cases, and these are simply cases where a listed company has made a statement in a prospectus or in some material that's been distributed in the RNS, the Regulatory News Service, or other public domain, which is said to be misleading. In some cases, it needs to be deliberately so, and some cases need reliance, some cases less so. So those are progressing, and of course there is action. Well, there's a lot of movement trying to push at the boundaries of group actions, representative actions. There's a sense that the courts aren't particularly keen on them, but at the same time, there are certain instances where these are these kind of claims are necessary. That also links into some regulatory activity that we'll no doubt talk about.
Sure. You mentioned a minute or two ago arbitration, and obviously you're very much involved in that. And before the cameras started rolling, we were discussing this. The benefits of arbitration have been long mooted as confidentiality, speed, and cost. Now, confidentiality exists, but it's getting slower. It's getting more expensive, and in the case of a lot of international arbitrations, nobody pays the award, and then you've got to enter into litigation to get enforcement under the New York Convention or whatever it is. So is arbitration losing its luster because it's losing its USPs?
I would say it's definitely not losing its luster, and if anything, it's evolving and it's gaining luster. I think speed and cost were possibly exaggerated even 20 years ago. The actual element of speed, I feel that was hampering litigation was the arbitration was the ability to get potentially quick judgments or quick action like summary judgment or expedited procedures. Most institutions have brought in procedures to deal with those. Of course, you have the time to set up the tribunal in the first place, but that can be well overseen, and generally isn't that much of a disadvantage compared to litigation. Cost in most of these international disputes is a concern, but the comparator isn't necessarily a concern. I don't think people necessarily write arbitration clauses into their agreements because they're cheaper than going to the courts. They will be more expensive and always have been more expensive than going to some courts, for example, in Germany or France, maybe not the UK or England and New York. But where I feel they're gaining is obviously on enforcement, the ability to enforce under the New York Convention, even if, as you say, you find that you have to, is much easier. The transportability of an arbitration award really is something, in some instances, priceless. The other thing I think is the flexibility of arbitration. I think quite often parties feel a bit hamstrung by procedure. I can only really speak about the English High Court procedure, but disclosure is expensive. The witness statement process is now very heavily regulated. There's strong case management, which has its advantages, but at the same time, people do feel hamstrung, and the procedure in England isn't necessarily reflective of the best procedure there could possibly be. So the idea, for example, that you would put in your the particulars of claim, and only afterwards do you really put in your evidence, and only after that do you really bring the strands together of what you've pleaded, with your evidence and your legal arguments, just before trial is a bit odd to US lawyers, to civil code lawyers, and I think the arbitration process provides a great deal of flexibility there.
You mentioned regulation earlier. You obviously do a lot of that. I get a sense, it's very hard to get statistics on this, so it's only a sense that on this side of the Atlantic, specifically the UK and the EU, regulators are becoming more proactive, while their counterparts in the US, where the White House has a very light touch, should we say, about regulating business, are going in the opposite direction. In the first instance, do you think I'm right to just have that general sense? And secondly, is enforcement sort of becoming more coordinated between sort of litigation and regulation? Do you find yourself working with regulators or entering into litigation as a result of regulatory action?
On your first point, I think there is a dearth of visible activity on the regulators' side in the US. I think depending on which regulators, but
some of them are being defunded completely. They can't do anything.
No, exactly.
I think the Environment Protection Agency is on its knees, for example.
Right. And I think you've definitely seen less coming from the SEC and the CFTC. But over here, I think I could look at, for example, the FCA, which has become more streamlined with a new leadership. They recently released their statistics in a new publication called Enforcement Watch, where I think it's more. They've opened, I think it's 23 cases in the past 6 months or so.
That's a lot, isn't it?
Yes, I suppose it is. It is a lot. I think you can compare it. There are some years where there was more, some years where there was less. But I think it's more for them all about opening and closing in a decent amount of time, rather than just opening. And I think that's very much the emphasis there. So I don't know whether it's more activity, but it's potentially more considered activity, and that's on the enforcement side. I think what we don't see so much, or I don't see so much as a litigator, is all the activity that's going on the supervision side. So before something gets to enforcement, and there are a lot of remedies that might otherwise be forced through by an enforcement team or through a process that are actually being done through the supervision process. So there's voluntary requirements and other types of solutions that are on the supervisory side. You see that in financial services. You also see that in tech. Ofcom, I think, tries to deal with things early, and I think you'll probably see the same in other regulated industries like water. Gas has obviously got quite a lot of activity coming on because of the conflict in Iran. So you will see, I think, more activity on that supervision side rather than the enforcement side.
You mentioned the conflict in Iran, and that is really causing just the latest in a long line of economic shocks. I mean, we could go back to 2008, but let's just go back as far as the pandemic, where no Western economy has really recovered from that. I mean, we are paying back billions because of that, and every time I get a tax bill, it becomes very, very apparent. I'm wondering, though, whether you have a sense of that the kind of the poor economic situation that we in the UK and most of the Western world finds itself in is impacting disputes, is impacting litigation, and are people using litigation in a sense as a way of fundraising? Are people sort of going through contracts and saying, I think we could, somebody's slipped up here, I think we might be able to make a bit of money out of this?
If I had that sort of sense and that knowledge, I'd probably be retired by now. Because you know, sometimes people will say, well, if the economy is going badly, there's going to be more litigation. That certainly was the
that was really the basis of my question.
That was the case, but in fact, it hasn't really been the case. I think that you know, maybe the last time it really was the case was, you know, things like the BCCI litigation, those sort of years.
Yes.
But since the 2008 crash, it's been less correlated.
Yeah.
You do in some areas. There will always be there will always be buyers of companies that, you know, seek to recoup a bit of the cost of the purchase of the acquisition through litigation on warranties, indemnities, and other stuff. There'll always be that. But otherwise, I think my sense is the situation has been the same for a number of years, which is that, you know, even if there are pockets of great growth and pockets of less, there isn't that willingness to go to litigation that there may have been before, or that the idea that litigation can be a source of profit for a company, certainly within companies and within the private capital space.
It's impossible to talk to a disputes lawyer today without talking about tech, because AI and blockchain is beginning to inform everything. From a personal point of view, have you found yourself having to go on a very, very steep learning journey to embrace very technical developments, high-tech developments which impact your world? And more generally, is this boom in space age, almost science fiction tech, actually changing the nature of your work and changing the nature of the kind of disputes you're seeing?
I think in terms of my daily work, there is an impact in the use of AI. And so it's in the use of AI, not just by myself and by my firm and by my team, where we do use it a lot, and have learnt to try and make it as efficient as possible. And I could say it's
no hallucinating case law, though.
It is incredibly impressive. I'd be on the side of the ones who'd say, actually, this is really good. And yes, if there are occasional case references that have gone awry, then there we are. So on that side, my day-to-day, my work, but also the work that my interactions with clients, because clients use AI. And they're asking questions, and they ask it to their AI, the AI that they use. They refine their questions. They come to the meeting, to the Teams meeting, knowledgeable and with the right questions. So a lot of litigation is really about issue identification. And I think AI certainly helps both the lawyers and the clients. With respect to the cases I'm seeing, I'm not particularly in the AI tech space, so I haven't necessarily seen any particular cases to do with AI, although I have seen quite a lot of cases to do with the integration of tech into the operations of companies and the integration of more sophisticated technology and the issues that raises in terms of, for financial services, in terms of compliance and reporting, and for other, I suppose, more consumer-facing industries in terms of people's private information and what they're allowed to collect, what they're allowed to retain, and how they're allowed to use it.
If we were having this conversation in 5 years' time, if you could whip out your crystal ball, Greg, your metaphorical, symbolic crystal ball, what do you think we'd be talking about that we're not talking about now? Basically, I'm just asking you to extrapolate current trends and see how things are going to go.
Well, I think we spoke about the conflict in Iran, and there obviously the conflict in Ukraine. I suspect, as with all global conflicts, there is going to be an increase in energy-related disputes, price escalation clauses, material adverse change. So that's energy pricing and energy deals and transactions. And I think they'll still be here in 5 years' time. I think we spoke about mass claims before, and I think there will be developments there. It's not clear what direction they will go, but there will be, and there may there may be some sort of reconciliation in the UK between the roles of private litigation and the role of regulators in that particular space, where there is a tendency in the UK to want a sheriff to oversee consumer issues, and that must be a regulator, and there must be a redress scheme, and claims management companies and solicitors and everybody else is a bad thing within that. But I think, you know, the post office scandal and many other examples show that that isn't necessarily the case, and there's a more nuanced picture. And the maturity and development of the opt-out regime in the competition sphere, I think, will show that. So I suspect there will be movement in that sort of mass claim area, although in 5 years' time I expect there will still be a debate about who's best placed to redress wrongs in that area. Private capital is very much in the papers at the moment, but has its own cycles, actually 5-year cycles. And there are people are saying that there will be and are disputes relating to the valuations that both private equity groups and private debt groups have given to their portfolios. So I would expect, and with the massive growth of private capital over the last 5-10 more years, I'd expect they're a dominant player in the economy. So I expect more issues around that. And then, you know, environmental claims, IP claims. There's more and more of those. You can see more and more city firms bolstering their IP activities, and then behind it all, the oft-forgotten insurance sector. I say oft-forgotten. I probably shouldn't say that, but certainly in litigation, you used to think insurance litigation has always been there. But you know, insurance lies behind everything. The insurers kind of know everything, and litigation involving insurance policies, but also involving insurers on the funding side, on the structuring side. I think they'll always be there.
You mentioned funding, which is always controversial. I mean, we've forgotten about the sort of ancient principles of maintenance and champerty now.
Yeah.
We've kind of shelved them, although strangely our Irish friends are still clinging on to those principles for dear life. Do you think that this will settle down, that we'll all soon forget about PACAR and forget about this debate and just say, you know, in the interests of justice, people should be able to get a claim funded, and as long as the funders aren't taking the mick, then, you know, fill your boots? Because I think so. I think this debate is going to end, and it's just going to become a normal part of the kind of legal landscape that funders exist. I'm just wondering if you concur with that.
Yeah, I concur with the outcome. I concur that would be the sensible outcome, and that's where we should get to. Quite how we get there and when we get there are different questions. There's obviously a lot of lobbying on different sides. I mean, I always look to the US and Australia when people say, "Oh, you know, this is in direct contradiction to the growth agenda," for example. And you see economies that grow very, very healthily, you know, regardless of these, in particular of the activities of funders. But there is a genuine, you know, debate and going on, and so I think that will go on. But I think the natural end of it is that there's a place for them.
Well, lawyers like debating, don't they? So there we are. One thing I think that will continue to evolve over the next few years is, as the world gets smaller and international cooperation gets closer, is people like you dealing with regulators overseas, especially in the EU. From a practical level, how do you find that? You know, are there sort of cultural differences dealing with the German equivalent of the FCA, for example, and how do you navigate that in very different legal systems with very different remits at very different regulators, but all pushing towards the same end?
Yeah, the simple answer to that, for now, and I think for the foreseeable future, is that you will always need a professional from the jurisdiction, a specialist, to help you navigate navigate that. You do get, for example, US lawyers in FCA investigations who are there, but even there, there's pretty much always an English solicitor specialist involved. So you do get that. I think with other systems, there's obviously the official language, the language issues, but there's also the specific cultural issues. I mean, law isn't just in a different language in the civil code system and the common law system. It's also a different culture, and dealing with the administration is also is another different culture. It's not adversarial, and even if some civil code procedures aren't adversarial, they in essence they are. So you needed a different mindset. You need a knowledge and an experience that will always need, I think, a local specialist. And so, you that's what you do. You build out your networks of local specialists with whom you can work.
Sure. And when a sort of new case involving sort of cross-border entities in multiple jurisdictions lands on your desk and you open the file for the first time, is there any particular jurisdiction that leaps out that makes your heart sink and make you think, oh my God, I've got to deal with these people?
I mean, there's nothing particularly comes to mind. But
nothing you're going to tell me now.
I was talking to some students, trying to explain to them, in particular, M&A litigation and what might happen. And I said there is always an employment issue in Brazil. There's always an employment issue in France, and there's always a criminal issue to do with tax in Italy. And those are just perennials. But otherwise, no, nothing comes to mind.
Well, that's a fantastic way to conclude this. Greg Lascelles of Hausfeld, thank you so much for joining us today.
Thank you very much.
Cheers.
Thanks.